the plaintiffs and the defense both want to see it done.
Yes.
Plaintiffs' lawyers want to get
paid.
The settlement done. I'm just going to say it, want to get paid. And
I
then
said it first.
You actually said it. I was thinking it, Keith. Thank you for taking the grenade on that one.
I had no problem.
You talk about it privately. We talk about it publicly. This is the Real Estate Insiders Unfiltered Podcast. Welcome again to the Real Estate Insiders Unfiltered Podcast. I'm your host, Dwiggy Dwiggins, along with my co-host, Mr. Keith Robinson, in the house.
Yes, sir. I got my Dwiggy back. Yes.
Hey, we're trying to get canceled on this pod.
Again.
We're definitely pushing the envelope.
Usually.
So we had Tanya Monestier, the law professor at University of Buffalo. Tell everybody what we talked about today, Keith.
She decided her little pet project was to tilt like Don Quixote at wild ass windmills, which is great. We talked about the problem with the forms in the settlement, how it all went, the irony of settlement dollars and how that whole thing went, how the consumer is going to get $20 and the attorneys are going to get $1 million.
She was pretty blunt about the fact that lawyers are making way too much money and the irony of the whole thing.
Yeah.
And she is a lawyer, so they're not happy with her, which you'll hear about.
Problems with the workarounds, confusion around the settlement agreement and how it was all rolled out. And what I was most impressed with, look, like she's putting her money where her mouth is. Like she's willing to go to the mattresses, has filed an appeal about unfair class action settlement process. And like she's taking it all the way. And when someone's willing to put their time, effort, energy, and money where their mouth is, like you get my vote.
Yeah, I mean, look, we don't agree with everything that she said, but I respect her for doing that. And she's also, what I found interesting, she's on both sides of the fence with this. So you're gonna dig this podcast because there's a lot of controversial stuff in here. So put it in your ears, kids.
Whoa, you took my line.
I know. Well, I had to. Sorry.
No problem.
Tanya, welcome to the show. We are excited to have you here today.
Yes.
It has been a year of interesting times in residential real estate.
Yeah.
We're recording this. There's probably a lot more drama that's going to be coming out after.
Usually.
What else is new, Keith Robinson? There's always something in the press these days.
I mean, I figured let's do a lawsuit episode. We haven't done one of those in about 5 or 6 minutes.
We haven't done any of those this year.
But Tanya has some amazing insight to share with us. Yeah,
she does. So Tanya, just we want to start with our first question with all of our guests, but I've got you have been in the legal industry since 2000. Make sure I get this right. Started as an associate and now are a law professor at the University of Buffalo, New York. You're not under a lot of snow. We learned before the show started.
It's basically Southern Canada, though. Come on. Sorry, Buffalo. Sorry, Buffalo. Don't get at me. I mean, you can get at me if you want to. You're too far away to do anything.
You've also written a book called The Shit No One Tells You About Law School. I love that already.
Immediately, it was like, book that.
There you go.
Yes.
There it is.
Book that guest. Buy that book. We'll put a link in the show notes.
Exactly.
Yeah, buy the book. Christmas is coming for Tanya.
There it is. All right. So give us the speed round on your background and then how you ended up where you are today, just for the viewers and listeners. Then we'll jump into our rapid fire.
Yeah. So thank you again for having me.
Of course.
I think one thing a lot of people don't know is that I'm Canadian. You might pick up on the accent here and there. So I grew up in Toronto. I went to law school at Osgoode Hall in Toronto, graduated first in my class.
Congrats.
I clerked for the Supreme Court of Canada. And then I did a master's degree at Cambridge University in England. So that was the educational part of my journey. And then I knew I wanted to go into academia. And it's very, very, very difficult to get a job in academia. So I took a job in-house at a pharmaceutical company for a couple of years as basically like being in a holding pattern until I figured out where I was going to land. I then did 2 years at a law school in Canada. And then met my husband and kind of blew up my career trajectory. The original plan was to stay in Canada, but my husband's American. And at the time, he was active duty U.S. Army. And so it just became very, very complicated. So I decided to go on the market in the United States. My husband got out of active duty, went into the reserves, and I ended up at a law school in Rhode Island. No real principal purpose other than they were hiring, and my husband could practice law in Massachusetts, which is adjacent to Rhode Island. So very good reasons for choosing that school. But it was always my goal to get closer to home. My parents' brother are in Toronto, and so I've been applying to Buffalo now I'd applied 11 years running, and every year I'd be like, "Dear appointments committee, are you hiring?" So finally I got the call a couple of years ago that they were hiring in my field, and I interviewed and I got the job, and so I'm at Buffalo now, and for me that's my dream school. I know maybe for a lot of people it's like Harvard or Stanford or something, but for me it's Buffalo. It's sort of, it mixes.
Because of the weather.
What's that?
Because of the weather.
Because of the weather. I love the weather. No, I love my family, and I love my niece and nephews, so I'm close to them, and it's what I've wanted for a while. So
and what do you teach?
I've been teaching for like 15, 16 years, but have been in Buffalo for, I guess, the past 3 or so.
And what do you specifically teach now as a
here
law
I
professor?
teach contracts, I teach sale of goods, and I teach conflict of laws, which is also known as private international law. So lawsuits which span borders and have issues related to choice of law, enforcement of judgments, and jurisdiction.
Well, congrats on
sounds
going.
riveting, doesn't it?
No, not at all.
mean-
So Keith knows I hate this stuff, but I actually like this stuff too.
Yeah.
So I was just kind of curious about that. I'm sorry for your husband screwing up your career path. I wanted to add that on behalf of him.
He's done, he got out of the Army. He's done pretty well. I have to do a little brag on him. He was actually lead counsel for Chelsea Manning in the WikiLeaks case.
Oh, dang.
So
Wow.
our lives kind of did a little bit of a detour. I was his unofficial co-counsel. So as much as I'm up in real estate's business, I was up in military law like a few years back.
We could do a separate podcast on that.
Yeah.
Talk about that whole
exactly.
WikiLeaks.
So, WikiLeaks, the biggest leak in military history, the biggest case actually in military history.
Dang.
And it was just my husband as Chelsea's counsel. So
Interesting.
it was interesting.
Well, that's got to be some wild stories on that one.
Yeah, there's a lot of people unhappy with him at the time. So, the feeling is something that I'm used to.
Yeah, we'll move that to the paid hour of our podcast for our subscribers. No, I'm just kidding. We don't have one of those.
So we'll do a couple real quick rapid fires. We do this with all of our guests, and mostly it's selfish for Keith to have more reading literature.
Yes.
So why don't you start us off, Keith?
Yes, I do selfishly ask this question. What's your favorite book or podcast this year or ever, one you recommend the most, and why?
I would say, I don't know if you're going to add this to your reading list, but
I might. You'd be surprised.
It's called Machiavelli for Women.
Okay.
And it's by Stacey Vanek Smith. And I mean, it was just an amazing insight into workplace challenges. And it was done in such a way that it's very different than anything else I'd read. There's just a lot of common wisdom out there, kind of the Sheryl Sandberg lean in.
Yeah, sure, lean in.
And I have found all that advice incredibly unhelpful. And I have been grappling with some things that have happened in my career, and it's difficult to make sense of them. And reading her book really helped crystallize that, okay, this is why this is happening. I'm not the only one. And, I rested kind of on my intuition, thinking that like, okay, this is probably why, but seeing someone else go through it and
call it out,
explain what's happening was helpful for me.
That sounds great.
I love it. So the Sheryl Sandberg book, she hasn't done one since then, I don't think.
I don't think so,
Yeah,
but leaning in hasn't worked out so well for me.
Well, we'll leave that.
I want to ask why so bad, but we'll just set that aside.
Right?
I was like, Keith, just leave that one alone. So
no way.
Yeah. Are you already going to get hate mail for the New York stuff you've already made comments on? So,
That's
all right. Mine is, if you could have lunch with one person, current or historical, who would it be and why?
Can I tell you, this question has stressed me out for 2 weeks.
Yes.
You sent it to me a couple of weeks ago, and I was like, who am I going to pick? And I felt like such immense pressure. And so like, I'll tell you who my immediate reaction was. I'm like, one of the Hemsworth brothers, because they're so beautiful. But I'm like,
Fair.
I don't think that's who
No,
we had
that's
in
as
mind.
good an answer as any other.
It is, right?
Yeah.
Right. And so my husband's like, no, you can't pick them. And I'm like, okay.
Damn
well, then
it.
I felt like I was going to go with Ruth Bader Ginsburg, but that just seems to be like the easy and like low.
kind
That's
of
a
a
good
layup.
one, though. And somebody's
Yeah.
picked her.
One, but it's
Yeah.
just, it's a little cliche.
A little
like, for me.
pedantic.
I mean,
Considering
you're a lawyer.
So I will tell you, I have settled on
Captain
because
America.
I couldn't find anybody who was like, I definitely know it's this person. I'm gonna take my husband to the lunch, and we're going with Peyton Manning. I almost said Eli.
Ooh, that
So, yes.
Okay. By the way,
Yeah,
that was not what I was expecting you to say at all.
I know.
So
Because I couldn't, like, there wasn't anybody where I was like, it has to be that person. But I know my husband's person is Peyton Manning. He's obsessed with him. So
okay.
I feel like
I love
that's
it.
where I'm going.
I love
So
it.
we had a third question we used to ask, and we'll dive in here in a second. We had a third question of if
We're
you could be a
testing the third one
superhero,
out?
would it be? Well, it's coming because she said the Hemsworth brothers, and one of the
Yeah.
favorite answers we got from if you could be a superhero, would it be? Was somebody said Fat Thor in the
I don't know. There's just not a lot of like women. I'd have to say Wonder Woman, I guess, because there's just not a lot of like women superheroes. So
Yeah.
that's a tough question. Is
All
there
right.
another one? Like maybe there is. I don't watch all those.
No, I mean definitely Wonder Woman's at the top for one.
I was Wonder Woman
knows,
for
but
Halloween when I was like 8.
There's Scarlet Witch. I mean, I could run down the list.
My
but I don't
daughter
wanna-
and my wife both dressed up as Wonder Woman for Halloween this time.
Oh,
So.
cute.
What did you
all
dress
right.
up as?
So
Never
we don't
mind.
get. I don't even ask Keith. We don't get a lot of time, so we do have a lot of questions. And so I'll start out with this. You've obviously been very vocal as well in all of the issues happening in this space, especially with the class action lawsuits. But you've been actually really you focused a lot more on the forms that everyone's creating, and then you've had concerns on that. And you've even drafted some of your own, and I've actually read them. So just for full context. And I will agree with you. I'm going to piss some people off, by the way, saying that out loud, that some of the forms in our industry are a disaster. And I'm just on record saying that some of them are really, really not well done. Some are better than others, but let's just take it from there. Talk to us about why you've been so vocal on it. It's obviously what you do and what you teach, but you've also drafted your own. Kind of go deep on this. What are the issues that you're seeing and how do we fix this?
Yeah, so I guess this all started with the forms, right? Like just way back in May, which feels like a lifetime ago. The settlement was announced, and it was clear, obviously, that there would be a lot of redrafting. And now that buyers were going to be required to sign these forms before they toured properties, I was interested in what these would look like for the consumer. And one of the first ones that was released, although it wasn't an official release, was the California Association of Realtors forms. And, my mind, those were just terrible. Like they were indecipherable, incomprehensible, and they had a whole bunch of stuff that was not consistent with the settlement. So
just what the consumer looks for, right? Indecipherable, incomprehensible.
It took me days as a contracts professor to read them and understand each provision. And some provisions I'm still not clear I ever understood.
This was just so I have context. This was a draft before the final release, just for context, or this
correct.
is
right. And this is the report I did for the Consumer Federation of America. I did both a report on the buyer agreement and the listing agreement. My understanding is that was sent to the Department of Justice, and the Department of Justice kind of called in NAR and CAR and whoever, all the acronyms, and had a meeting. And then the forms were held in abeyance and were revised. And the forms that you see now from the California Association of Realtors were not the first version of the forms. Right. So that was kind of my first experience with the forms, but it's not just California forms that are terrible. Like I probably shouldn't name names. So let's just leave it at that.
No, come on. No one's listening, Tanya. Just go alphabetically. Put them on blast.
I don't need any more cease and desist letters, okay? So there are a lot of really bad forms. And when I say bad, I really mean two things, right? So the first is there were forms that were not compliant with the settlement. It was very clear to me that brokerages and associations were attempting to circumvent what I thought were the very clear parameters of the settlement. So the so-called workarounds, which we can talk about later. And then the other thing was they were very consumer unfriendly in terms of having kind of, draconian or unconscionable provisions and being drafted in a way that just people wouldn't understand. There was no effort to make these forms consumer friendly. And, like when you're dealing with the biggest purchase of your life and you have this relationship where you're going to pay someone like tens of thousands of dollars, I feel like you should understand exactly what that relationship looks like and what your rights are. And the forms don't do that. Like they're not written for the average consumer. They're written by lawyers for lawyers, and even then lawyers don't understand that. So that was kind of the impetus behind it.
I have a general forms question and then other ones too. But look, if you're in business long enough, you're going to get sued, right? And I feel like forms evolve out of protection, not out of clarity. So how do you balance? I guess this is a question as a forms person. How do you balance a clear, consumer-centric, simple, easy to read form, which tends to be general and vague and lightly explain something, right? And then the specificity that you need for real protection to protect yourself from being sued in the future. How do you balance those two things when you're crafting a form?
I think it's a false dichotomy because no amount of writing protects you, right? Like anybody can sue over anything at any time. Now, whether a court gives effect to a given provision, we don't know, right? So nothing protects you from actually getting sued. Maybe it helps you win the lawsuit, right? But you can't stop somebody from suing you.
Which is a whole other conversation.
Sure.
By the way.
Right?
Okay, so fine. But like the goal of a form is to try to facilitate a transaction, right? And of course, I agree with everything you're saying about the more clear, the easier it is for the human being to process, the better that it is, period, end of story, full stop. And, you still end up, if you get sued with a generic form, it's worse than if you get sued with a specific form, right? From a protection standpoint.
No, I don't think so.
Then why is everything I've ever signed completely legalese? Why are loan documents 450 pages?
Lawyers who are trying so hard to cover every single basis and thinking of scenarios that like happen once in 20 years. And in doing that, they muck up the forms and they make it like they're preparing for contingencies that won't happen, and they're contracting out of liability that they don't have liability for, right? So it
was a case that happened and there's an outlier now that they're putting that in as protection because of one situation that occurred. I
guess what I'm saying though is every legal doc I've ever signed has something stupid in it, and right, that doesn't make any sense. Like why? I guess. Sure, I agree with what you're saying with regard to the CAR forms and the NAR forms, and some of it I think there was a compressed timeline and they were rushing, trying to get stuff out, and then they've got a constituent group that wants things one way and they're trying to honor that. And, if you're crafting a form after a class action lawsuit settlement, it's probably going to tilt a little more to the attorneys being involved in the form creation than the non-attorneys being involved in the form creation. It just feels, as a person who's outside of the legal process, right? It feels like you're damned if you do and damned if you don't. If you write a generic form that's good for the consumer, your lawyers are going to freak the F out and tell you can't put that form out there, right? And then if you write one that the lawyers are happy with, then we get on a podcast with you talking about how stupid the forms are. Like, what are we supposed to do as a business owner who just wants to help human beings transact, right? That's all I want to do. And I feel trapped.
No, I totally understand that, but I think it's bad legal advice to say that the more you put in here, the more protected you are. The protection is an illusion. You can't contract out of certain things. So attempting to do so is going to not advance the ball. And just repeating what the law is doesn't advance the ball. So like in my agreement, I have an accompanying document that's like 16 pages where I go through everything I included and everything I excluded, right? So you can go through line by line and say, like, why doesn't she have that in there? And I explain why, right? Because the law already recognizes this, or because this is not going to be legally effective. So, I think that the knee-jerk reaction, even among lawyers, is to throw everything in there and hope it's helpful. But as somebody who knows contract law quite well and who has, dealt with a lot of contracts, this overkill mentality doesn't advance the ball. It provides the illusion of protection without any actual protection. And in doing so, it creates what everyone agrees is a decidedly anti-consumer form, right?
Right. Yeah. I
So,
just
And this
hope
doesn't
you.
even apply to real estate. This is just in
No,
general.
this is just
This is just a. I mean,
this
is it
is just in general.
in general? Yeah. Okay. So, can you give me before we go to these other questions?
Yeah.
Can you give me just a couple of examples on the things that you said you felt like were outside of the settlement from your perspective in the forums? And then I want to just one or two, and then a couple things that you think are anti-consumer. So I just want this out. I want to hear people to hear what your concerns are.
And you mentioned a specific doc. You'll share that with us so we can share it.
Yeah, we'll put it in the show notes.
Yeah, we'll put it in the show
I
notes.
actually have them, Keith, but we'll get them in there. Yep.
Yeah, I mean, so one of the big things right from the very beginning was whether parties had the ability to modify the compensation upward, right? So if the original buyer agreement said 2% and the seller was offering 3%, could you change it to 3%? And from the very beginning, I said, this is not allowed. To me, the writing in the settlement agreement was very clear that you couldn't do that. But despite that, right, people were like, oh, of course you can modify. And I'm like, no, that's not what the language says. And so many of the forms contained a reference to modification. And if not in the buyer agreement, they just created a separate form that allowed for modification. And then all the training sessions conducted by lawyers, right? And by the top trainers at brokerages are saying, you can modify. And this also applies to bonuses as well, particularly like builder bonuses. So builders offering 5%. Yeah, just get the client to sign off on that and then you can get it. That wasn't allowed according to the wording of the settlement. Like I said, it was very clear to me from day one that was not allowed, but no one ever from NAR, from the plaintiffs, went on record and said, no, you can't do that. They just allowed these practices to continue. So now it's like we're trying to put the cat back in the bag, right? Because these forms contain reference to modification. There are forms for modification. Brokers think they can do this. And there's like me and you telling people you can't do it, right? And
well, just for everybody to listen, as somebody who was sued and settled, just for the record,
right?
You can't modify your compensation up. I don't care who is telling you that. As somebody who actually dealt with the plaintiff's lawyers, you can't do that. And just to back up Tanya on this, logically, it would make sense. Why would you ever sign a buyer rep agreement before showing a property, agreeing to your fee and services, and then be able to modify it down the line when a seller is offering more, there's a bonus? That's the whole point of it, is in their view, not mine, but their view, I believe, is to stop steering from occurring. Am I wrong?
No, absolutely. Right. Yeah. I mean, it even leaving aside the wording of the settlement, like it defies common sense to think that this would be permitted. Right.
What about commission sharing in the forms? I mean, there's been several statements by Douglas Miller and others that if that not going to put his words in his mouth or their words, but something to the extent of, if they find that a committee of people that are creating compensation sharing in forums props up compensation, that the industry will be back in the same spot for Morel and Sitzer. Is that your understanding of that too? Or are you less concerned about commission sharing, cooperative compensation being put in forums?
I don't. The settlement does not prohibit cooperative compensation.
Agreed.
Right.
Yep.
And I think that some consumer advocates think it does. And but it doesn't. And I think it's very clear from the filings that is still permitted to continue. If reference to that is in the forms, I don't see that as any different than just doing it. Like the fact that it's in a form doesn't change the nature of it. So I think the bigger question is whether cooperative compensation will survive eventual, maybe DOJ antitrust scrutiny. Or, I mean, I don't know if there's going to be a second wave of lawsuits, but I don't see the fact that cooperative compensation is in the forms as violating the settlement in any way. Might it be independently problematic? Yeah.
Okay. All right, Keith, anything else on that before I move us forward on some of these other questions?
Nope.
Yep. Okay. So you filed an objection to the proposed NAR settlement, which was eventually denied by the judge. And it was like maybe a few weeks ago. Talk to us about your position on this and why you filed the objection.
Yeah, it was never my plan to file the objection. Like I said, I got into this being concerned about the forms, and the deeper I
Right.
got into it, I saw that there's all these like interrelated aspects to the settlement. So like it's not just about the forms and the workarounds, it's about some practices that have developed or been reinforced post settlement that I think have the effect of keeping the current system in place and undermining what is certainly the intent of the settlement. So the more I saw of that, the more concerned I became. And I think you know this, I had a meeting with the DOJ this summer, and expressed to them some of my concerns and what I was seeing. And so had one Zoom conversation, one subsequent phone call, a couple of emails. It's clear DOJ does their own thing. And so I decided at that point, like given all the information I had accumulated, I wanted somebody to know what was going on. And so I reached out to Mr. Ketchmark and his associates, and I said, I've been in touch with the DOJ. I've done all this research. Like you say you're watching everyone, right? Like he went on record saying, we are watching you. And so, I took him at his word, and I offered to share the materials I had with him. I didn't want to turn this into an issue, right?
Mm-hmm.
And I wrote to him and like I said, two of his associates, and didn't hear back from any of them. So, it was clear to me that they weren't interested in the research that I had done or plugging some of these holes. And, then when September rolled around, it was very clear all this stuff was still continuing unabated, all the workarounds, all the things we were seeing at open houses. And, I thought, like, if I were a judge approving $1 billion settlement, I would want to understand how this was playing out in the ground. And the way that a class action works at the settlement stage is no one has any incentive to rock the boat, to tell the judge about, any potential unfairness or inadequacy in the settlement, right? The
Go
players
deeper on
now
that.
are aligned.
You mean the plaintiffs and the defense both want to see it done?
Yes.
Plaintiffs' lawyers want to get
Paid.
the settlement done. I'm just going to say it, want to get paid. And
I
then,
said it first.
And then I know that's fine. You actually said it. I was thinking it, Keith. Thank you for taking the grenade on that one.
I had no problem.
And then obviously defense wants to get it solved
Closed.
as well because
Yeah.
they want to get out of litigation and move on with their lives. I just want to pin that because this is where you and I align. The problem there is both parties want to see this go away, and essentially it's the judge's responsibility to look at this and go, does this actually make sense for both parties? Is that correct with my statement?
No, it's a judge's responsibility. Sorry, I didn't mean to be so.
No, that's fine. No, I'm not a lawyer.
Go ahead.
Just tell me. Yeah, it's what you're
My
here.
favorite part of the
My students don't like it when I correct them.
It's my favorite part of the podcast so
judge
far.
Is not supposed to make sure that it's fair to both parties. The judge is supposed to act as a fiduciary for the class, for the absent class members. And so it's different to ask, is it fair for the named plaintiffs and or the attorneys and the defendants? Like, who cares if it's fair for the defendants? The question is it fair, adequate, and reasonable for the 40 million absent class members? And a judge approving a settlement has a heightened duty of care, essentially, to act as this fiduciary because nobody is now representing the class anymore. Right?
Interesting.
And so this has nothing to do with this particular case. This is a structural feature of class actions that has been criticized for 30, 40 years, right? I can pull 12 law review articles that talk about how the posture changes from adversarial to cooperative at this point. And so no one will tell the judge anything bad about the settlement. Like, why would you? And that's why the objectors are, in theory, supposed to have a very significant role as being a check on this process. They're supposed to be an independent monitor. And there have been a lot of academic critiques about approving class action settlements, and even propositions of maybe the judge should hire a law professor or an outside expert to opine on the reasonableness of the settlement. So there's a lot of talk about how we need to pay special attention to a class action settlement. And certainly for an antitrust settlement that disrupts an entire industry, that's costing billions of dollars, and that is purportedly like groundbreaking, you would think that a court would want to hear, anything about the settlement from, absent class members. So that's kind of what precipitated my decision to object. I was like, I know about the settlement. I've done a lot of research on it. Like, I think there's a perspective here that's being missed. And I think the judge should know about some of these bad things that are happening out there, to the extent that that weighs on the appropriateness of the settlement, or even just having the judge ask some questions, right? Like having the judge say, is it true that these forms that are being promulgated, by associations with the blessing of their attorneys, is it true that they are all allowing modification? Like, I would have expected some sort of dialogue there where the judge would have asked about some of these practices. And so that's what I had envisioned going into the objection. And how it played out was very different. There was not that dialogue. There was not, I think, that maybe interest in getting deeper into the propriety of the settlement.
So what I'm hearing is, which is really fascinating. So I, as you can imagine, have spent a lot of time studying class actions in the United States, and it really is genuinely a problem. I mean, what I've read is that it very rarely actually helps the people that were affected by it. Whether, to be clear for everybody who's in the industry, I'm not agreeing or anything about this particular case.
James
talking
Dwiggins
about the
said
practice
he hates
in general.
Aaron Brockovich. That'll be the headline.
But it is interesting, because as I've looked back through not just this, but many class actions in the United States, it's the actual plaintiffs, the class that's harmed gets almost nothing. Like,
Yes.
it's literally nothing. Mm-hmm. And I'm not going to opine one way or the other. Obviously, my position is I'd like to see this move on, and the case is now, obviously, we'll talk about this, but the case has been, or the settlement's been approved by the judge. But one of the things besides the workarounds, and I do want to talk about that because I want to get into this. And so everyone, Tanya's been talking about this. We're going to address what her view is on workarounds, as well as the plaintiff's interpretations of some things. But one thing you did, which I'm sure is controversial, like we are right now for you, was you questioned the amount of money the lawyers were being paid as well. And so can you talk to us about that a little bit?
Yeah.
To put you on the spot?
No, it's fine. It reminds me, I got an email from someone recently and said, it must be tough to continue when everybody wants you to go away. And so that's sort of how I feel, right? Like, first of all, it was the realtors who were kind of mad at me for I guess, calling out some of these practices. And now the attorneys are very upset about me daring to question their fees. And, so.
It is ironic, isn't it, though, in a way that
oh, yes.
they're getting mad that they're being questioned about their fees. I mean, the irony is just thick.
I don't understand.
Wait, what do you mean?
It's a lot. It's a lot to sort of process. So yeah, they were not happy that I questioned their fees. And if you read their response motion, it's just like, claws out. You could tell that they did not like that part. My intention going into the objection was to focus on the real estate part of it. The other thing you have to remember, I had 3 weeks to do this, and I have a job. So, I did this at night and on weekends, and it's a lot of work to put together a 136-page objection. And so, I'm on page like 75, and I'm like, I can't even bother with the attorney's fees. This is just too much for one person to do in their spare time. And the more I looked into it and I read their submissions and I read their expert declaration, the more I thought, this really just does not sit right with me, because on average, a class member will get about $20, $25, and the plaintiff's attorneys are going to get $333 million. And that number is so far above the range of typical numbers that are awarded in these mega fund cases that I found it unconscionable and yes, ironic, right? Like to take on an industry to say that they're charging inflated commissions and then taking your inflated numbers, your $2,200 an hour, and inflating that by 3.62. Like it's just too much. But
so
to me,
how did they get? I mean, I don't want to say how to get away with that. I guess is this just sort of if people agree to it, you agreed to it. So
no, the judge, here's the thing that I think some people don't realize about attorney's fees. I was talking to a reporter a couple of weeks ago and she didn't realize, right? She's like, well, why do you care about the attorney's fees? And I'm like, because the more the attorneys get, the less the class gets. It comes out of the same pool.
Right.
So if the attorneys get only $100 million, that extra $250 million goes to the class members who were the ones that were, allegedly harmed here, right? So like there is an inherent conflict of interest now with the attorneys asking for 33%. Because that money comes out of the class recovery.
It wasn't their total billable hours something? I'm correct me if I'm off, but it was like something like $96 million or something like that.
Yeah, it was $92 million was their billable hours, and again, their billable hours include a buffer, right? So I think their hourly rates are geared toward the type of case and the risk involved. So in other words, the hourly rates are already inflated. For lack of a better word, right? So, the people charging $2,200 or $1,500 or whatever, that already accounts for the complexity and novelty of the case. And then asking for a 3.62 multiplier to me is pretty offensive. And it's just almost unprecedented. There, I don't think is another case that I've been able to find with so little value to the class and so much value to the attorneys in this neighborhood of $1 billion. So, it's
thank
shocking.
you. By the way, thank you. I want to say that for calling out, I'm essentially not your peers, but you know what I'm saying? Like you're calling out something that's not right. We're not afraid to do it here when we talk about our industry that needs to change. And,
Sure.
I just wanted to say that because it is disheartening, even though we're paying into the class, not neither here nor there. The fact that the people that were supposed to receive money aren't actually getting a majority of it is also like, well, what the hell is this? This is, for me, it just feels like just corruption. Like the whole system has to change because that doesn't make any sense. Like if you've got your billable hours, if we're going to agree to a compensation rate in a contract and we can't exceed that, then you have to agree to a compensation rate for what you actually charge and can't exceed that either. Like to me, that's just, like am I?
So, but
I mean, in this case, like certainly the irony is paramount, but like ultimately the question is like, what is the fee that they deserve and what is reasonable? And, they turned a $1.8 billion verdict pre-trebling. So it would have been like $6 billion against, a couple of defendants on behalf of Missouri plaintiffs they turned that into just a $1 billion settlement with the entire country with dozens of defendants, right? So like, I don't view that as like a super successful result when you had this giant verdict against only a couple of defendants on behalf of residents of one state to then settle for less than $1 billion. And like, again, to me, I'm not saying this about the real estate industry. I'm saying this about measuring the success of the litigation so as to justify the fees.
Yeah. I for context, the timing for all of this is hard. I'm not defending the plaintiffs, by the way, but the industry this is the worst time in residential real estate that I've been in my career since I've been alive. There's not a lot of money going around right now because the industry's just broke. If it had been in 2021, it'd probably been a different time frame, but you're not wrong in it. It's been very hard for the industry to look at this and then also be like, I don't understand how that works out that way. I mean, it just feels ironic to it. Just
it doesn't feel ironic. It feels wrong.
Well, fine. So
it's beyond ironic, right?
Yeah.
Like,
I
I
think
guess
it's
that's
both.
how does this happen? Like,
well,
Yeah,
I mean, that's
it's
a
a
whole.
feature of class actions, and I'm hoping the appellate court looks at this carefully and looks at recent precedent. We'll see, but it's just, I mean, this is the problem with class actions generally, not this class action.
Right.
There's a perception. I think there's a line someone said once, like in a class action, a class member gets a toaster and the attorneys get $1 million, right?
Right. Right.
Just for time's sake, I want to come back to the appeal, and we'll talk about that any way that you can. So the plaintiffs finally, unfortunately, in their response to your objection, came out and clarified what their interpretation is of the settlement. I've read that as well.
Yeah.
Can you go down that list real quick so that people can hear? And I'm assuming this is your interpretation of it as well. Does it align? Does their interpretation align with yours, I guess is the question.
Yes, except in one way. But
okay, then let's go down the list. Yeah, tell us their interpretation, and I would love to hear yours too. So.
Right. I mean, so like as part of my objection, I had said that there's all these workarounds happening. And so I went through one by one. And so that they in turn addressed each one of these things. And so the first one was the amending the broker agreement upward, right, to get more compensation. They said that can't be done, right? And I would add, they didn't get into this in detail, but like whether you modify or you rescind the original agreement, enter into a new one, like whatever permutation of modification you're trying to do, not allowed, right?
You can go down. I'm assuming if you wanted to lower your compensation, you just can't go up. Is that, I'm trying to get very specific here because I want the industry to hear interpretations.
I think you can go down. I think there's a different consumer protection problem potentially with going down. So this is how I see the problem with waiver, in the sense that like I worry about realtors including a higher number than they would otherwise want in order to create a buffer, right? So that if additional money is on the table, they put in 4 or 5% so they can get up to that. But then they orally assure the buyer, don't worry, if the seller's only offering 3%, I will waive the excess. That is allowed. But I worry about the specter of like fraud on the consumer, right? Because when something is said orally outside of the agreement, that doesn't come in. And yet people rely on that and I think could get duped.
But doesn't the specificity say that it has to be specific? You can't say a range or you
she
can't.
meant going at a higher number and then knowing.
No, I know that, right?
Oh, okay.
But she also said doing it orally versus doing it in writing, but they can't do that in writing. Like if someone wanted to use that as their structure and say, hey, look, normally I charge X and I'm going to try to get it from the seller, but if we need to do it for less than X, that's fine, right? That statement I assume is okay. But then if you get to some number at which like 5% instead of 3 or whatever, but they can't put that in writing, correct?
But if they can do it orally and it's effective, then they should be able to do it in writing and have it be effective, right? So the waiver thing is tricky, right? Because it's not a range. It's I will get 5%, let's say, but if the seller's not willing to pay more than 3%, I will waive the excess. I think that's allowed under the settlement, but I think like you're just getting into iffy territory in terms of consumer protection and fraud and kind of like violation of the spirit of the settlement, not the letter, right? So the waiver thing concerns me, but for different reasons. So there's, modification not allowed, modification upward, that is not allowed. Secondly, this is just a variation of the first, which is bonuses paid in particular by builders or by sellers. That's not allowed, right? Because that's essentially getting sign off on a modification. So that is also not allowed. A big one that I'm glad they clarified, but doesn't seem to have like changed anything so far, are the touring agreements, right? Touring agreements as they are currently conceived of in the industry are not allowed, right? Not in the way that they're being done. Not really sure, like,
go specific. When you say not being in the way they're being done, get specific for me there. Meaning,
yes, of course. So my understanding, of course, like they can look different ways at different places, right? But my understanding is a lot of them are done where it's like, I'll take you around for a week for free, right? Like a trial period. And then if you want, we can enter into a subsequent agreement. So to the extent that the subsequent agreement covers properties from then on, I think it's fine. But I think what is not allowed, and what the plaintiffs confirm is not allowed, is for any subsequent agreement to essentially relate back to properties that they already saw under the free agreement. So if you toured a property during that 1 week, you want to proceed with that property, and I mean, you're not paying any commission. Right.
Right. So just for clarity, the example being, I have a touring agreement to tour properties for $0 for a week. And then that's the fee you're charging then
for those properties.
And if you go back and then they want to buy one, you've already agreed to $0 essentially to buy that property. You can't then enter a buyer rep agreement for an additional amount. Did I clarify that?
Exactly.
Okay. Which would be logical.
All the Zillow agreements are kind of structured where they would seem to permit that kind of retroactive, like changing that and saying, well, these are brokerage services, these are touring services, and you're not allowed to do that, right?
Okay.
And it wasn't consistent with the letter of the agreement, but also it just makes no sense, because then if I were a broker, I would just enter into a touring agreement, like an indefinite one. And then once I found the property, I would enter into like an agreement at whatever rate. Like
right, at the rate in which the seller is offering, because then you're right back to the way it was before.
Exactly. So that's why these touring agreements.
Well, so how though, like, I understand everything you're saying and I agree with it.
Yeah.
And you have potential buyers who want to see a home because they're curious about it. You have agents who want to show them that home, but they've never met, they've never talked, they've shared 2 emails total, right? Yeah. It probably, the relationship is not at a place where it makes sense to say, how you don't know me, you've never met me. We've traded 400 characters twice, and now sign this agreement that says you're going to pay me X even though you don't know me, right? Like there's a structural problem there that needs to be solved. So how do you solve that problem?
I didn't draft the agreement. Like, I mean, I think it's terrible. This would not have been the solution I came up with, right? So, I mean, I guess the answer to the question is you contact the listing agent as a buyer and, go in unrepresented until you decide who you want to work with. Or, a broker just takes the risk that they show you property, and at least for like a certain period of time till they get to know you, they're not going to be paid any commission. I mean, like, I don't. This is a problem that the
none of which is better for the consumer.
No,
right?
No, and I'm not saying it is, right?
Yeah, no, I know you weren't. I was just pinning that point, right? Like the frustration here that the industry, and for the people who just want to help and serve people, right? Like that's really vast majority of the industry isn't colluding and trying to do the things that they've been accused of in a lawsuit and lost, right? Yeah. But so to go through all that, to feel like your reputation has been besmirched, and that's a fun word on a Monday, and then to be told basically you're stuck and you want to continue to serve these people and you want to follow the rules. Most people truly want to follow the rules, whatever they are. Just tell me what they are and don't change them, because I just want to help these people with this process. And then to do it and just be like, well, I guess you got to send them the listing agent. Like, it's such a bad answer for everybody.
Well, I mean, is it more, I mean, Keith, I'm throwing it back at you. I guess it's more along the lines of the buyers are going to have to get used to doing interviews before they start looking at properties like they do on the list side, and they got to pick an agent, and the agent.
But that's just not how it works.
I'm not, to be clear, the
reality,
know that.
The reality is I'm curious before I'm ready. And they're attracted to the home. They're not attracted to the agent yet. They are attracted to the dream of home ownership. Like, that's just not how it works.
What are the other ones, real quick? Because then I got to follow up on this that I want to make sure I ask. And
sure, yeah, and I don't disagree with you, right, on any of this, and it is not consumer friendly, but in terms of what's allowed and not allowed under the settlement, this is what they've clarified. Ranges. So, I mean, it was very clear ranges weren't permitted, but Georgia Association of Realtors did something crazy where they allowed like a minimum maximum. And again, this was sanctioned by their general counsel, right? And so that's
It
not
literally
allowed.
says it in the settlement, ranges of compensation or not. It literally says it in the language of the settlement.
Yeah, well, except they phrased it where it wasn't a range. They did it like kind of tricky, but it was clear what they were doing. I'm not sure how anybody could have read the agreement the way that they did. So that's not allowed. The other thing is, this is where I think I disagree. Whether you can tailor the representation agreement to whatever the seller is being offered. The plaintiffs say no, that's not allowed under the settlement agreement. And I would agree, like it certainly violates the spirit of the settlement agreement. But I don't think that it violates the letter of the settlement agreement. So,
I need you to get specific there. What do you? So are
You
you
mean
saying?
like if a seller's off, if I have a signed agreement for 3 and the seller's offering 2.5 and we just agree to do it for 2.5? Is that what you mean?
I wasn't.
No, that would be like a waiver, right?
Yeah.
What some agents are doing, because buyers are nervous about committing to a sum of money, like for all time and all purposes, is they're doing representation agreements per property. And so before going to see 123 Main Street, you sign an agreement once you know what the seller's offering for that specific property.
I understand.
And so you might have 10 different representation agreements covering 10 different properties.
Got it. It's one per client. Set your fee in advance. So they do an
exclusive just specifically for that property, blah, blah, blah. Yeah.
What happens
Can I just stop you for 2 seconds?
Yeah.
You're going to kill me, but my battery is running out on my computer, so I need to plug this in.
Yeah.
Go. No problem. Go do it.
All right.
We'll pause right now.
Thank you.
So Keith, while she's doing that,
we'll pause right now for station identification. Sorry, I just didn't want to say that.
What is so we're in this world where they have to sign in advance. What do you recommend people do then? They're going to sit down, sign a buyer rep agreement. The buyer doesn't want to do it yet. Like how do you approach
for me,
that?
I would have a representation agreement based off of the depth of relationship with the client, right? So if I've sold you 4 properties before and I'm your person and we know I'm your person, then when you reached out to me about 123 Elm Street, I'd probably just send you a buyer rep agreement and have you sign it, right? The normal exclusive, we're going to work together, new rule, this is what we have to sign before we show property.
Got it.
If I've never met you before and you're an online lead and we traded a couple emails and I'm meeting you at the property, I would do the softest, like non-exclusive, single property, 27 minutes, if that's what makes you feel whatever they would feel comfortable agreeing to and signing is what I would do, because the only reason I'm there is to establish rapport and the relationship so that I can ask for the honor of getting to interview for the position of being their agent.
It's good advice, Keith. I hope everybody listened to that. Tanya, I got a couple questions here just for time. What happens where does this go? The plaintiff's lawyers think it's one thing. Let's just hypothetically say associations and brokerages think it's another. I'm pretty clear about the fact that I think it's important the industry is listening to what the plaintiff's interpretation is, because if not, Tanya, what happens if
the plaintiff's attorneys are going to come back after them? I mean, why wouldn't they? They have all the research. They have, $92 million of hours poured into it. Why not use all that work and now go after the violators, right?
Okay, so basically that ends up in more litigation and massive legal fees defending it, and most basically probably settlement because it's cheaper than going to trial. Am I correct with my statement by making that pretty blunt?
I mean, I think so. I mean, the other thing I would say is, like, I think that's in theory. I don't know that there is much of a desire at this point on the part of the plaintiff's attorneys to continue with this, right, and to enforce this. So that's more my fear, right? From my perspective, my fear is not that people are going to be sued again, but that I don't want to say that they're not, but that these what are clear violations of the settlement agreement will continue unabated. And what really concerns me is that NAR has not, after the plaintiffs filed that motion, NAR has not gone on the record to clarify anything. It doesn't seem like people are talking about this. I haven't heard talk about revising forms. So I feel like people are sort of like ignoring that this happened and pretending like it's business as usual. And,
But the risk
maybe,
is essentially more
well,
litigation and violating the settlement, and that essentially could be very expensive for anyone that's doing it. Is that a correct
yes.
statement? Okay.
Yeah.
All right. So let's wrap with this. I don't know what you can talk about it, so I'm just going to leave that open. But you are planning to file an appeal on the approved settlement. Is that correct?
Mm-hmm.
What goals? I don't know what you can share. What are the goals you're
Yeah.
trying to accomplish?
Yeah, so I thought about this and whether I wanted to continue because, like I said it before, I have a day job. And so this takes up a lot of time. And, I don't have the time or the ability to do this by myself. So, I'm in the process of hiring counsel. And the organization that I'm hiring, it's called the Hamilton Law Institute. And this is all they do, right? They help objectors object to unfair class action settlements. And so they have a very good track record with that. They know the ins and outs of this. And so I'm very, comfortable with that relationship. So I'm glad that I'm not going at this alone,
Yeah.
but that I have, I think like collectively, they probably have like 67 years of experience between them. So we will be going forward. They will be taking, I think, a lot of the lead in terms of drafting, but I'll still be involved. And, for me, this started off as being about the real estate industry, and obviously it still is. But I am equally concerned about other things that I saw play out in this process. The attorney's fees is one of them. The order for class action objectors to appear in person, something that I think is an unconstitutional order,
Hmm.
and that I think deprives people like me of due process, right? Like I spent inordinate amounts of time on that objection, like 50, 60 hours. I spent like $50 just to mail it. Like I did all this stuff. And, I had spent the summer doing research leading up to it. So it was like the work product really represented months and months of work. And then to be
Mhm.
told, no, you need to fly to Missouri so you can speak for 2 minutes
Right.
about what's already in your papers that I've apparently read. Like it just made no sense. And so seeing some of these things play out really concerned me as a lawyer, right? And as a professor. I used to teach class actions, right? So, as somebody who has taught class actions, I understood how extraordinary the fee award was, and B, how extraordinary the order was. And so I don't think either of those things is right. And I think for the legal profession, somebody needs to follow up on that. So, that kind of motivated it.
And this is going to be a process. I'm assuming an appeal takes years. Is that a fair statement? I don't
Yeah,
know
I
what the
mean, I don't
process
know. I
is.
think that the Eighth Circuit is kind of fast tracking this. I saw some kind of scheduling order for like January submissions. We haven't filed the notice of appeal yet, so I don't think anything is going to be required until probably like the March, April timeframe. But it might be sooner than you think.
Okay.
But I don't know.
Okay. All right. I have one last question, then we'll let Keith ask the famous question he always asks all of our guests. I'm really curious to hear your answer on this one. But mine is, do you see more litigation coming? You kind of alluded to no potentially, but I'm curious. Lots of lawyers I talk to are like, yes. And then some are like, no. So what's your take? Is it the same plaintiffs, maybe different plaintiffs?
I think I'm not sure that it'll be the same plaintiffs, right? I mean, there are people who haven't been released, and so those plaintiffs are going after the defendants that haven't been released. But in terms of whether they're going to circle back with the violations, that's the part that I don't know. I think the DOJ. Things might be on the back burner for a while under the Trump administration, possibly. I don't think that this is like the end of interest in real estate for the DOJ. So I feel like this is something that will be hanging over the industry's head for a long time. I thought their last minute kind of submission with the not the touring agreement, the buyer representation agreement, and the timing that was sort of like odd. I don't know where that came from.
Everybody said the same thing like
Yeah.
2 days before. I don't think the judge was impressed at all. Yeah.
Like,
No.
okay.
Yeah.
You know, so I think, and then there's also just parallel lawsuits that are happening. Like right now, you have the like home buyer lawsuits proceeding. You have some of the quote unquote copycat lawsuits that, you know, who knows if they're going to be subsumed. It seems like the judge says they're part of the class, but if the appellate court disagrees, those could continue. So I just see like a splintering, and like I do think there is going to be litigation going forward. Exactly like what shape it's going to take and against who, I don't know.
Okay. That's probably a good lead in for Keith's question to wrap this up.
And this is what we always close with. If you were an agent or a broker, what's the one thing you'd implement today to help your business going into 2025?
Yeah, I thought about this question too. Like I as like a lawyer and law professor, I feel like it's, I'm a little bit outside my lane here.
So touring agreements, is that what you're going to say? Implement touring agreements. Is that what you're going to
say? No, I mean, I like, you know, one of the things I hear all the time from industry participants is how they, you know, they value the consumer, and the consumer's at the heart of this. And I think that needs to be shown in different ways. And one of those ways is through the paperwork, right? I think as somebody who has bought and sold a home in the past couple of years, and this is my second time, the whole process is very overwhelming. The paperwork is overwhelming. As somebody who understands the paperwork, it's overwhelming. So I think for the average person on the street, this is just like, it's so much. And so to the extent that you could take this very complicated process and paperwork and make it simpler, like that would be a huge value added for a brokerage. Like, and I commend EXP taking the lead on this, at least, you know, redrafting their buyer seller agreements with that in mind, because I think that really does put your money where your mouth is. Like if you say you value the consumer, you can't ask them to sign this 8-page 8-point font document that nobody could understand, right? That I don't think that's really valuing the consumer. So I think, you know, it's not.
I blame the lawyers.
What's that?
I blame the lawyers.
I blame the lawyers too, right?
Yeah.
And the complete risk aversity of the lawyers, right? At the end of the day, like I said before, like you can get sued over anything at any time. Like if all you do is try to draft around being sued, like you're just gonna have a terrible work product. So you need to figure out an appropriate level of risk tolerance and then truly prioritize the consumer in all this. And, you know, like my draft agreement, it's not the perfect agreement, but it's thought out. It takes into account like cognitive science. It takes into account the literature on plain English. Like so much of the legal drafting doesn't account for the realities of consumer contracting and what we know about consumer behavior. And so it's like, you know, like for instance, just a silly thing, but they've done studies where all caps lettering, people who are seniors have trouble processing all caps lettering. Most people do, but people who are seniors in particular, that's a very difficult thing cognitively for them.
It's because we don't like getting yelled at.
Yeah, but so many of these agreements have these like lines with all caps letters, right?
Yeah.
And so just like knowing who your audience is and what would be helpful for them is something that's invaluable, but no one really takes the time to think about like how to present
details.
Information in an accessible way.
Yeah, I'll give you one and then we'll wrap here. I love the fact that nobody actually reads anything that we're being sent. Because when was the last time that even you or I read the terms of service on a website that we click I agree on? You know, a big issue is DocuSign. When you put forms in there and you're sending it to somebody, they hit start, they sign, they don't read it. I mean, that's a whole other conversation.
That's a whole other problem, but I agree, right?
Yeah,
so like we have two like confounding problems, the unreadability and then the format in which you are asked to read something that is unreadable.
Right.
Tanya, thank you so much for being here. It was very insightful. You know, Keith and I love to have people with differing points of view on the show. I know some people will not like the fact of that, but that's what we want to do. I think it's important for people to talk and communicate more. We loved hearing your perspective on things. And we'd love to have you back in some period of time and see how this all shakes out. So again,
Yeah.
appreciate you being here.
And thanks for the work. Like, thank you for sacrificing the time to really think about it through the lens of what's best for the human being who wants to buy and sell houses.
Great.
Because
thank you.
if everyone could just do that on all sides, this would be a much more efficient and better
sure.
process for everyone involved. So thank you for the work.
I agree. No, thank you for saying that.
Thanks, Tanya.
Thanks.
Listen, we care about you deeply, which is why we never want you to miss an episode of this podcast. Subscribe now. It's just a push of a button.